Okay, welcome back to the Law&Crime Network. My name is Bob Bianchi, and we got a lot on the plate today. This is a Dan Abrams production, so you know it's gavel-to-gavel coverage on the most impressive, if you will, important and amazing cases throughout the United States. It's great to be back with you. I look forward to being there with our chatters, who are our second jury. I was just speaking to them this weekend about all the great work that they do in terms of giving us some questions. I got some great guests as well. Okay, this is going to be some week here at the Law&Crime Network. Kirk Burkhalter, one of my regular guests, one of my besties. Welcome to the show, Kirk.
Nice to see you.
Good to see you. 20 years as a detective, first grade NYPD. You actually did some sleuth work here behind the scenes, identifying what jacket I had, what coat I had with my jacket. And as a professor at New York Law, as well as a person who has done everything in terms of legal commentary, writing articles. Kirk, you are a star here at the Law&Crime Network. Generally speaking, what are your first things that are coming out to you legally about what's happening in this case, the retrial of Winslow?
So the first thing that jumps out at me is all the evidence of what we call prior bad acts. Mm-hmm. So these are things that the defendant has done in the past, be it the result of a conviction or someone else coming in saying that he did these things to me, even though he is not on trial for them. So there are certain rules of when that can come in, and this is really important because it's prejudicial to the jury. And you know, some of those rules, the most importantly is if it tends to show a common method of operation. You know, I always call this is like the Batman villains. You know, does this show that this person is the Joker, always leaves a card or whatever the case. So that's one way it can come in, or the identity of the victim or misidentity of the victim. Otherwise, as you mentioned, you run a risk of an appeal here by letting too much information in.
Yeah, and you know, something that I find interesting in this particular case is this is what we call 404B evidence that gets admitted. And you know the Cosby case. And in the Cosby case, they didn't have 4 or 5 victims. What they did was they put those witnesses on that were outside the statute of limitations, but they didn't actually have charges against Cosby for that. Here, he's having like 5 mini trials, if you will, in one. And I think that that's a really unique way of going about it, and I think even more prejudicial to the defendant. We'll see what the appellate courts say about that down the road. But in the Winslow case, you remember there was Jane Doe number 5, and this was another exposure case in a gymnasium. Another update that we have for you is the judge has made another ruling that case is going to be severed, split apart, separated from this, unlike the first trial, and the jury will not hear any evidence with respect to this particular case. Now, that's very interesting to me because that's a different kind of ruling than what the first trial was. Many lawyers, I would imagine, and defense lawyers are going to say, hey, they shouldn't even be trying Jane Doe 2, 3, or 4. You should pick a Jane Doe and go with that particular person. And if you got to try 5 cases, you try 5 cases. That's the way it's got to be. So anyway, we're going to throw to that on direct examination of Jane Doe number 5, just to take a look-see at what the jury will not hear in this case. So, Professor, you talked a little bit about that 404, evidentiary issue. Now, interestingly, right now, this Jane Doe 5 that we're listening to from the first trial is going to be severed, and the jury will not hear any information. I'm curious. There's this New Jersey case where there was an alleged exposure, and now that the prosecution is trying to get that in. Do you think the judge may have telegraphed that I'm not going to allow more extraneous pile-on information to occur in this trial? What do you predict is going to happen here?
I mean, if I had to guess, I would say the answer would be yes. Because why would you allow further information if you're starting off by limiting the amount of information that comes in? Further, this actually works, I believe, for the defense. I think that the witness that we just saw was rather credible. Even though they didn't get a conviction on the second count, and that's partially because she was very honest and truthful about what she did not see. However, she was a very credible witness, so it certainly helps the defense if she's not on. But I think we'll see more limiting of evidence coming in.
And I want to take a deeper dive into this 404B, right? So that's called other act evidence. And whether you like it or you don't, and you're a professor, and I know you're teaching your kids this all the time, and you do crim pro class and crim law class, the idea of that is not to have a trial by character assassination, and that is to protect even the innocent as well as the guilty. So, in other words, we just can't keep piling on and piling on things about everything that's bad that went on in your life, unless it goes to motive, opportunity, intent, plan, preparation, absence of mistake, a rebut, a defense. So there is some wiggle room there. As a prosecutor, though, I used to say just because you can doesn't mean you should, and I've actually limited my own introduction of 404 evidence in cases where the judge said it was permitted just to avoid the appeal. Talk about that importance of tactically doing things so that you don't have to come back and do what they're doing here right now, retry a case.
Absolutely. So first of all, a jury can certainly get hung up on whether they're convicting, there'll be an argument as to whether we're convicting this person for the crime that they are on trial for or all the prior bad acts. It is extremely prejudicial that if you did something 20 times in the past, this 21st time, am I all of a sudden going to believe that you didn't do it? So that's the basis for the rule. Further, as you mentioned, appeal. So if you're the defense attorney and you're sitting here and all this evidence comes in, make no mistake about it, you're just simply writing down everything that you're going to use for your appeal in the future. And there, what's interesting is appeals are based on a matter of law, not a matter of fact, not what the jury should have believed unless there's a baseline. So you have a judge, a member of the court, weighing whether or not the lower court got the law correct. And to be quite honest, you always have a better shot with a judge reviewing the law than with a jury reviewing the facts.
Well, the professor just gave two really great practice points for all our folks out there that love true crime and that are maybe young lawyers themselves or lawyers themselves. One is that it's not just another trial on appeal, it's whether or not legal principles were violated. They don't second guess the juror's decision on the facts. And that's really, really important. And just again, the lawyers are writing down each and every time they can create an appellate issue. And the prosecutor's job should make sure that that pen stays as filled with ink as it did when the trial started. We got to take a break here at the Law&Crime Network. Great to be with you guys. We'll be right back.